Title IX was signed into law on June 23, 1972 by President Richard Nixon. The purpose of Title IX was a good one. It was to ensure that women college students had equal access to educational programs and activities. Before the advent of Title IX, many of the best colleges and universities in America did not accept women or had quotas limiting the enrollment of women. Female athletics were rare and received much less support and funding than male athletics. A very good piece of legislation took a very bad turn on April 4, 2011, when the Obama administration's Department of Education sent out what later notoriously became known as the Dear Colleague letter. The Office for Civil Rights within the Department of Education radically reinterpreted Title IX as giving the federal government the right to dictate the specific procedures that colleges and universities must use to adjudicate student-on-student sexual assault allegations. The hammer was the withdrawal of federal funding. In other words, the Department of Education back in 2011, when it sent out the Dear Colleague letter, specifically threatened colleges and universities with the withdrawal of federal funding if they did not investigate and adjudicate sexual assault allegations in the manner that the Obama administration believed was the proper manner. The result has been a kangaroo court system of investigating and adjudicating allegations of sexual assault, oftentimes involving investigators that have no law enforcement background and panels of professors, students, and administrators that have no legal training and, more importantly, no legal training in sexual assault cases. The framework put into place by the Dear Colleague letter took away basic due process rights that a male student should have when having to defend himself against charges of sexual assault and other types of sexual misconduct. The standard of proof in one of these college proceedings is preponderance of the evidence, not beyond a reasonable doubt, which the accused student would have if he was defending himself in an American court of law. Preponderance of the evidence I like to describe as 50% plus a feather. That means that the college has to prove the male student responsible by 50.01%. That's a lot less favorable than the beyond the reasonable doubt standard. The Dear Colleague letter framework also took away the accused's right to have a lawyer speak for him and defend him. Although I believe it is important to have an experienced Title IX lawyer defend you if you are accused of sexual misconduct in one of these Title IX proceedings, that lawyer, one thing that the lawyer cannot do is utter even one word in a Title IX hearing.
I know the rules don't apply. I know the Congress doesn't recognize attorney-client privilege, husband and wife privilege, priest-penitent privilege. I know those things are all out the window, and we rely on just fairness, Mr. Chairman. Fairness.
Let the witness object if he wishes to.
Well, sir, I'm not a potted plant. I'm here as the lawyer. That's my job.
The Dear Colleague framework also took away the accused's Sixth Amendment right to cross-examine his accuser because cross-examination, according to the bureaucrats in the Obama administration's Department of Education, would traumatize the victim, or to use the jargon of the Me Too movement, the survivor. The Dear Colleague framework puts into place a system where no jury or even independent decision maker actually makes the decision of responsibility or not responsibility. It is generally a panel of professors and administrators that are actually employed by the same university that's prosecuting the student. The student under the Dear Colleague framework cannot present any character evidence. This is, again, a very important weapon that somebody accused of sexual assault has in an American court of law, and it's been taken away by the Dear Colleague framework. Under the Dear Colleague framework, the accuser can actually appeal a not responsible or innocent finding, which in an American court of law is not the case. Once you are found not guilty in an American court of law, that's it. You can't be retried. There is no appeal. It would be a violation of the Double Jeopardy Clause of the United States Constitution. And lastly, the Dear Colleague framework requires accelerated adjudications of 60 days or less, which in most cases deprives the accused male student of the ability to do a thorough investigation and craft a defense to the charges. The Dear Colleague letter quickly created its own entrenched bureaucracy on college campuses with the advent of Title IX diversity and equality offices, Title IX investigators and coordinators, and Title IX training programs. These Title IX bureaucracies are often, in my opinion, very accuser/survivor-centric. There is often a presumption that the accused is untruthful and that he is guilty. On September 17th of 2017, the new Secretary of Education, Betsy DeVos, withdrew the Dear Colleague letter guidelines and gave accused students back their basic due process rights. This caused a firestorm of criticism. Unfortunately, the vast majority of colleges still use the Dear Colleague guidelines. This has been a brief overview of Title IX's history and the current landscape. I have been representing students accused of sexual misconduct in Title IX cases since 2011. I have achieved many not responsible verdicts for my clients. You can win your Title IX case and clear your name. However, you need a skillful Title IX attorney to guide you through the field of landmines that the Title IX bureaucracy has created for accused students.